webinar today to discuss data privacy laws in Kenya. As it's been stated, data is the new oil and helps companies predict trends, identify opportunities, and also stay ahead of competition. So the key objective of the Data Protection Act is to ensure that businesses use data responsibly and also give consideration to the right to privacy of data subjects. So that said, the laws should not be seen as a barrier or a hindrance to effectively undertake business operations. So allow me to give a quick background and introduction of the data protection laws in Kenya. So the main act is Data Protection Act number 24 of 2019, which came into effect in November of 2019. Subsequently, we had 3 regulations coming into effect. One is the general regulations. Then we also have registration of data controllers and data processors, which gives a step-by-step process on how registration can be done by these 2 groups or categories. Then we also have the complaints handling and enforcement procedures in case a data subject has a complaint to make with the Office of the Data Protection Commissioner. So some of the highlights and the key objectives of these laws is confirm you can hear me, Anthony?
Yes, Mary, I can hear you.
Okay, thank you very much. So some of the key objectives is one, to regulate the processing of personal data, also to ensure that processing is done in accordance to the guidance and principles laid out in the laws. And thirdly, is to protect privacy of individuals. So this is basically to buttress the provisions of Article 31 of the Constitution, which gives individuals or citizens the right to privacy. These laws also establish the legal and institutional mechanisms. That's why we have the Office of the Data Protection Commissioner to deal with the enforcement bit, and also to provide rights and remedies to individuals in case their data privacy is breached or is not in accordance to the provided laws. So I know you've heard of some of the key terms, a controller and a processor. So mainly a controller is a natural or legal person who determines the purpose and means of processing data. A processor, on the other hand, is somebody who undertakes these instructions. So just to give a quick example to distinguish between the two, is that you can have a good example would be where you have company A, which is dealing with certain services or products, and they're looking forward to marketing these services of products. So company A engages company B, which has a call center, to undertake these marketing services. So the company A would be in charge of determining how these personal data will be used and even the kind of tools that will be used to process this data. On the other hand, a data processor will normally just take instructions from the processor and doesn't have the autonomy of this data. So there are times where you might have one entity acting as both a controller and processor, depending on the nature of their business. Then we also have a data subject who is a person, natural person, and is normally the subject of personal data. And I won't belabor on the other points as they give further explanation on how data is processed and what is categorized as sensitive personal data. So then the Act gives a quick highlight of some of the principles that guide data processing. This is contained under Section 25 of the Act. So one is lawfulness, fairness, and transparency, which basically means that data should be processed in a lawful, fair, and transparent manner. Then we also have purpose limitation. So this basically means that data should be collected for an explicit, specified, and legitimate purpose. and not further in a manner incompatible with those purposes is collected during collection. Then minimization. So this basically means that when data is collected, it is to be limited to what is necessary in relation to the purpose for which it was processed. Then we also have accuracy, storage limitation, and the limitation on transferring data outside Kenya. So under the Act, it provides that unless there is proof of adequate data protection safeguards, a company is not allowed to, or an entity is not allowed to transfer data outside Kenya. So two key things. They need to prove that they have adequate safeguards or measures within the organization. And two, they also need to get a consent from the data subject in question. Then I'll go to the registration process of now the data controllers and processors. So it's the Data Protection Act gives a brief overview of who is required to register, what are the parameters that are determine how much money to pay or which category you fall under. So however, there's an exception. Data processors that have an annual turnover of less than 5 million and less than 10 employees are not required, are exempted from mandatory registration. However, there are certain categories of entities that are not exempted. So this basically means whether their turnover is less than 5 million or they have less than 10 employees, they require mandatory registration. So one is canvassing political entities that are used in canvassing political support among the electorates. Then we also have gambling, educational institutions, hospitals, property management companies, and companies that deal with provision of financial services, which we commonly call the digital lenders. Then we also have businesses that deal with or process genetic data and businesses in the transport industry. So before I finish my presentation, I'll just take you through some of the things that have been coming up in the data protection space and how the Data Protection Office has been acting or giving guidance towards some of these complaints lodged with the office. So to register as a data controller or processor, as an applicant, you require to lodge your documents with the Office of the Data Commissioner. I've recently done a couple of registrations and I can clearly say that the process is pretty simple, but requires the guidance of a data protection officer or a legal consultant to undertake this. So one is to duly fill an application form generated from the website of the Data Protection Commissioner's Office. Then two is to pay the prescribed fees. And when you log into the website, you're able to see where your company falls. So there are parameters that determine how much money a company should pay. And depending on two things, the annual turnover and the number of employees within that company. Then you also need to provide a copy of your incorporation documents, then particulars of the data controller or processor. This includes the name, address, and contact details of your company. Then you also need to give a brief description of the purpose for which this personal data is going to be processed, and a description of categories of personal data being processed. So once you lodge this application and the same is approved by the Office of the Data Protection Commissioner, you get a certificate of registration, which would be valid for a period of, for a period of 24 months. So that's 2 years, after which you require to get a renewal. So then there are various rights of data subjects to protect them. One is they have the right to be informed of the use as to why that data is being collected. Two is the right to access their data. Three is the right to object to the processing of all or part of this personal data. Right to correction, right to deletion. So right to correction is whereby if your name is misspelled or any of your details are not correctly captured. So you can do a formal request to a data controller or processor to remedy the same. Then there's also the right to withdraw the consent. So if, for example, you've already given the consent, you're at liberty to withdraw this consent. Then there's also the right to receive personal data concerning them in a structured, commonly used and machine readable format. Then I'll quickly move into the obligations of data controllers and processors. These are the companies that are now undertaking the actual processing of this data. One is the obligation to apply for registration, as highlighted earlier on. Then there is a requirement to have a designated data protection officer as directed by the commissioner's office. Then they also have the obligation to process this data in accordance with the Act, conduct what we famously call data protection impact assessments. So if you're a company or a business that is looking forward to undertake a project that involves personal data, you're required to undertake a data protection impact assessment to weigh the risks that would be involved with processing of this data. Then there are others, some of them which include putting up protective measures for processing of this sensitive data. Then in case there's a breach or your systems have been hacked or for any reason, you're supposed to notify the Office of the Data Protection Commissioner within 72 hours. That is within 3 days of this breach. And there is a prescribed form given under the regulations. Then the obligations for data processors are pretty similar to what we discussed with regards to data controllers. So I won't belabor on that as well. Then we have mainly what we call cross-border transfer of data. So this mainly deals with companies that transfer data from one territory to the other. There are 4 key guidance for before transfer of this data is done. So one is to ensure that the company undertakes appropriate data protection safeguards. So one of the safest way for you as a company is to ensure that there is a contract in place that is going to give direction on how this data will be transferred and other guidelines. 2, there's something we call an adequacy decision made by the data commissioner. So they normally they're required by the law to publish a list of countries or territories within that country for which a decision has been made that they have the adequate levels of protection when it comes to processing of data. So I'm here to see that on the office from the website. But I know in the few coming days that these are one of the steps that they intend to undertake. Then there's also the transfer as a necessity. So this is sort of an exception where cross-border transfer of data is allowed, where it's for the performance of a contract, matters of public interest, and in the exercise of a legal claim. Then you require key and very key and important is that you require the consent of the data subject. So the consent has to be explicit and they need to be informed of the possible risks that could happen when this transfer is being undertaken. So allow me to just give a brief highlight of the complaints handling and enforcement procedures as encapsulated under the regulations. So the Office of the Data Protection Commissioner is allowed to receive complaints of data breach or within 7 days. They acknowledge this receipt. So there are various orders that they can give once they receive a complaint, but normally they'll do an assessment to determine the veracity or the validity of this complaint. So then there are various penalties that are defined under these laws. So one is that the commissioner can issue an enforcement notice. So it's more of a remedial notice. So they can issue a notice directing the company that is in breach to take remedial measures or corrective measures to ensure that data is protected. One case we saw recently, the office recently published one of the hospitals that was in breach of these data protection laws. And when they issued these enforcement notices, that they requested the company to take remedial measures as they had breached the data protection laws. We also saw them publish, and this goes to show that they are not a toothless dog. They published various digital lenders that process personal data and were in breach. So it shows that people are actively adapting to these laws, and they're warming up to them, and people are not hesitating to file some of these complaints with the office. So they can also issue a penalty where there is failure to comply with an enforcement notice. So in case the hospital doesn't undertake corrective measures, then the office can be able to give a penalty. Penalties not exceeding 5 million or imprisonment of a term not exceeding 2 years or both. Then there's another point where if you obstruct a commissioner in exercising their functions, then they are at liberty to to enforce these penalties. So for our business, what are some of the approaches you can take to ensure that you're continuously protecting your data? One of them would be to come up with a strategy or roadmap, and that is why you require a data protection officer to guide you in some of these steps. So as a company, you can come up with a strategy or a roadmap on how you're going to assess the risk appetite within your company. Then there's also the part of organization and accountability. So this is basically engaging everyone, the key players within that company, and making sure that the roles are very clear to ensure that data collected is processed in the right manner. Then there's also the part of policy, processes, and data. So this basically means the company coming up with policies that guide this data, could be taking technical or organization measures. Then there's a bit of training required within the company and communication. So creating awareness and training your staff how to handle this personal data. Then ultimately, there is the audit and certification, conducting privacy impact assessments and ensuring that you're embedding privacy by design and by default within your organization. So thank you very much, Anthony. I'll pass over the opportunity to Laibuta to continue with the presentation.
Thank you, Mary. I know there were some comments on the chat regarding the presentation. So after this, we will share the presentation with each and every one of you to be able to review at your own convenience. So at this point, I'd like to introduce Mugambi Laibuta, an advocate of the High Court and also a certified data protection specialist. Mugambi, please, karibu sana, and the floor is yours.
Thank you so much. I trust you can hear me.
Yes, yes, we can.
I had some 3 slides. I don't know whether I can share it myself. And of course, you can't see me because my video is also disabled. So
yes, you can share. You can share. You have the rights.
Okay. Okay, so this is me. I think, yeah. So just give me a moment. Yeah, you can see my slides?
Not yet.
Yes?
Yes, you can.
Okay, thank you so much. Okay, so I'll just talk about compliance strategy. So I have what I call a 13-point strategy, 12, some steps that you may look at adopting within your organization in terms of compliance. So the first of this is data protection training for all within the organization. So in my experience, there are different ways you can go about this. There are institutions that provide, so the question is, what is training? Ideally, you'll find most of us go through what we call a sensitization training, where you find somebody comes to your organization for a few hours, and this basically helps to highlight what are the key issues, like what Mary has presented. So you get to think through your organization, what are the key issues you need to prioritize in terms of compliance. But we also need to think about what really is training, because the question is, if Libuta reads the Data Protection Act and makes PowerPoint presentation about it and presents it to a group of people, does that amount to sensitization training? Of course, we also have institutions that carry out this training. We have law firms, we have academic institutions with individual consultants. We have tech companies that carry out this training. So it is very important that as an organization to carry out a training needs assessment, so as to understand what exactly do you require to be trained on and how long will this training be. If the training, in my view, if the training is like 1 hour, 2 hours, that's really not even a sensitization training. In my number of years of experience, I think when you carry out a sensitization training of at least 6 hours, covering all the aspects of data protection compliance, then you can say that is a sensitization training. Of course, in terms of certification and deeper training, you need at least five days or more. But it is important that everybody within your organization, starting from the board. So what I usually do is that I ensure that even before or even after training members of, like senior management or staff, it's important to have a discussion with the board, because there's need to be buy-in by, if your institution is run through a board, then you need the board on board, because the board is what will provide resources. The board will ratify, will make resolutions to hire, for example, a data protection officer to provide office equipment and resources for this individual for compliance. So ensure that your board is sensitized, your senior management, and everybody within your organogram. So from the board, from the chairperson of the board to the lowest person within your organogram, they need to know what their role is in terms of helping your organization comply with the Data Protection Act. The second thing that is critical is that you do what we call, you create a data inventory. So as you create a data inventory and as you're carrying out this data training, there are different assessments that you can do to assess the level of maturity of compliance of your organization. One, you can carry out a privacy assessment. A privacy assessment really looks at the aspects, the points that I'm going to talk about today, or a privacy impact assessment, or you can carry out a data protection impact assessment. So it's important to distinguish between a privacy assessment, privacy impact assessment, and a data protection impact assessment. A privacy assessment and privacy impact assessment is to look at the whole organization and their level of compliance. And as you're carrying out this privacy impact assessment and you identify the gaps, one of the ways to create a good strategy, a good data protection compliance strategy, requires what we call a data inventory or a data map. Within your organization, you need to know what kind of personal data do you process. And the good thing about a data inventory, it also helps you identify the institutional data that you process. So a data inventory is basically what it is, an inventory, a list. What personal data do you process at the finance and admin department, at the compliance and risk department? If you're a bank, at the credit department, at personal banking, corporate banking, etc. So where you have a list or an inventory of the personal data that you process, then you're able to identify certain things. You're able to identify the sources of that data, who is responsible for that data within the organization, whether you're collecting too much data, what are the security protocols for this data? Do you share this data with people outside the organization? So a data inventory from the training and the privacy assessment or the privacy impact assessment, the data inventory helps you to create a concrete strategy, because that way you'll identify where the gaps are, you'll identify who is responsible for what data, you'll identify what kind of protocols and controls you need to put in place to comply with the act. Then there's the third one, you develop institutional data protection and policies and privacy notices. So within your organization, there's need for you to have an internal data protection policy. Institutional data protection policy is like your human resource manual. Your human resource manual tells you what time you need to come to work, how do you interact with your colleagues, what are the promotion procedures, what are the demotion procedures, disciplinary procedures, how do you take sick off, how do you interact with other members of the organization. So an institutional data protection policy has the same role, but with a excuse me, with a focus on data protection. So as an organization, who makes the decisions? What kind of data do you process? How do you escalate issues that arise, etc. Then you need to have privacy notices. Privacy notices is basically the information that you give to employees. So, and remember, sometimes when we are complying, we forget them. We look external and forget to look internally. So remember that even when you are complying, it's not just the data of your customers you're looking at. You're also looking at the data, the personal data of your employees, the data of your consultants, of your agents, of your vendors. So for this group of people, you need to have a privacy notice. And a privacy.
Anthony, Bucha, sorry for interrupting you, but your slides are showing in a presenter mode. Please put it on a slideshow.
I thought okay. Now?
Still on presenter, still on, yeah, it's okay now.
No, it's okay.
Okay, so as I said, privacy notice is basically the information that you give people, what data you're collecting from them, why you're collecting it, how you're going to keep it secure, how long you're going to store that data, any risks, etc., etc. Then you need to appoint or designate data protection officers. Here it's tricky because, of course, you might feel that this compliance is costly. And when you're thinking about, do you really need to employ a new individual to be a data protection officer? And the answer is no. Section 24 of the Data Protection Act doesn't make it compulsory for you to have a DPO or a data protection officer. However, in some sectors, my advice is always that you need to have a substantial data protection officer. If you're in banking, if you're in insurance, if you're in health sector, if you're in education, if you're in finance, etc. It's important to have a designated data protection officer because the workload and the responsibilities of this person are immense. But where you cannot hire one, you can designate one of the C-suite officers to act as the data protection officer. But the challenge with this is that there'll be a conflict of interest at a particular point because the DPO usually carry out assessments to see whether people within the organization are complying with the act. So if this person, so for example, if you designate your legal officer, your chief legal officer to be the DPO, will this person be able to audit themselves? And you see that brings up a conflict of interest. Something else is that you need to ensure data subject rights fulfillment. So basically here, and these 5 and 6 are, I mean, they can be read together. So when you look at section 26, for example, do you inform your data subject of the personal data that you process? Do you have processes where these people can access, where data subjects can access their personal data that is in your custody? Do you have mechanisms where people can object, can correct, or have deletion of false or misleading data? So this basically means the regulations, the general regulations provides for some forms. So do you have those forms perhaps in on a web portal, or do you have them physically where people can come and fill in and get access to their email, to their data, to object, etc. Consent management framework. If you look at if some of you have looked at the administrative notice issued by the Office of the Data Protection Commissioner, one of the issues that the data commissioner is asking these digital lenders to prove is that they got consent from the data subjects, or from the people whom they lend this money to. So if you're in an industry, for example, if you're in banking, if you're in insurance, if you're in this digital lending, if you are in online betting, whatever industry that requires consent. So here, when you look at Section 32 of the Data Protection Act, it states that it is the data controller or data processor to prove that you received consent. So how do you do this? Then the question is, what framework do you have in place? Do you get consent from somebody ticking a box, filling a form online, filling a physical form and signing, and you have a record of that? Because if you cannot prove to the data commissioner or to the data subject that you got consent, then you might be in trouble. 7 there, you need to carry out data protection impact assessment where necessary. And where necessary. When you look at Section 31 of the Data Protection Act, it says that it is where processing operations might result to the high risks of the rights and fundamental freedoms of a data subject. So you'll find it's not in all cases that there'll be high risk. And it's not all cases that you may need to consult the data commissioner prior to processing data, because Section 31 also says that you consult the data commissioner if your processing will result in high risk of the data subject. So you'll find a lot of people say you need to carry out a DPA, you need to carry out a DPA, but it's not important to carry out, it's not a must to carry out a DPA in everything that you do. Is for you to prioritize and identify what data processing operations will amount to high risk. If they don't amount to high risk, then probably you don't need to carry out a DPI. That is why I said, and it's not in the act, that you need to consider carrying out a privacy assessment and a privacy impact assessment before starting compliance. Because that way you'll also identify areas where you need to carry out a data protection impact assessment. 8 there, you need to put in place incident and data breach management strategies. And as you realize, in terms of compliance, there are areas where other professionals within the institutions will assist you. For example, if you're talking about data breach management, the CISO, the Chief Information Security Officer or Chief Security Officer will come in handy, because of course, as an institution, the assumption is that you may have an ICT policy, or you may have an ICT cybersecurity strategy, you may have a physical security strategy. So all this together with compliance with the data protection, they come in together. Just the same way as when you are ensuring data subject rights fulfillment, you need to ensure that you have your chief information officer will have put in place mechanism like identity and access management. So the data protection officer or the data protection team does not operate in a silo. They have to collaborate with other people within other departments or other groups within the organization. So incident and data breach management strategies, this could be borrowed heavily from your cybersecurity strategy, from your physical security strategy, because data breach, and also you need to distinguish between a data breach incident and a personal data breach incident, because at times there could be a data breach or a breach of your systems, but you may find that there's no personal data that has been breached. So here, you also need somebody who understands the distinctions. That is your CISO, your CSO, your DPO, who will be able to advise. And also, of course, a lawyer to advise you on the ramification, on the legal effects of the breach. You need to think about carrying out vendor risk assessments. A lot of risks that might be occasioned upon you are from your vendors. and not just from the vendor. So here we're also assuming that your organization has a risk register. And within your risk register, you've also identified how to deal with how risk treatment. What is the risk treatment for each risk that you identify? So here 9, you need to, as I said, you need to think about it in 2 ways. One, do you have a risk register? Do you have a risk treatment?
Hi, Laibuta. Sorry,
Hi.
sorry to interrupt. If you could be able to minimize, it's currently showing number 11. You could maybe minimize so that we can see the whole screen, the whole presentation.
I actually didn't change anything. And this?
It's showing 2, 3, and 4. It's 10, 11, 12. So you can speak through 9, but we can't be able to see number 9.
I don't know what the issue is, but anyway, I'll talk you through it, so no problem. Sorry, I have no idea what the issue. What can you see now?
Now it's showing us 10, 11, and 12, but you can be able to speak through.
Okay, so 9 basically.
On my end, I'm seeing 9, 10, 11, 12 actually.
Okay, since I think I have 1 or 2 minutes, sorry. So in terms of the vendor risk, so as I was saying, you need to have a risk register and a list of how you're treating each of those risks. And for your vendors, you need to come up, and here when you're talking about vendor risk assessment, this ties into procurement because it's your procurement department that helps you to get vendors. Therefore, in your procurement policies, in your procurement documents, you need to have a framework with which you identify, you audit your vendors to see whether they are compliant with the Data Protection Act. Number 10 there, as you're complying in the process, you need to review contracts, agreements of staff, contractors, agents, and suppliers, especially if any of these do process personal data on your behalf. This could be, for example, your agents, insurance, it could be your cloud service providers. Actually, colleagues, one of the biggest problems that you'll have in terms of compliance, especially when you're dealing with contracting, is cloud service providers because they are very rigid in terms of reviewing their contract. They'll always tell you, if you don't agree with our template contracts, you can go to another vendor. So if you're a small MSME, then you might not be able to wriggle your way out of that. But of course, if you're a large corporation in the financial communication sector, you tell them, okay, if you don't want our business, we can go elsewhere. And of course, they'll want to negotiate. So you need to review contracts, look at the provisions, especially where the contracts relate to you sharing data with with vendors or third parties, so as to look at what contracts you need to include. So you see here at step 10, so when you looked at 9 on the risk register, that is your compliance and risk officer will will work together with the DPO. Here 10, in terms of reviewing agreements, contract, etc., it is your legal officer or your legal advisor working together with the DPO. And also there at 9, risk vendor assessment, I've said it's the procurement officer working with the DPO. Then 11, please keep a very good record of the kind of processing operations you do. So you need a good record of all this I'm talking about, of your training, of your data map inventory, your data map and inventory, of your policies, of people who you designate as DPOs, of how you fulfill data subject requests, how you respond to data subject requests. You need your consent framework. If you carry out a DPIA, data protection impact assessment, that needs to be on record. Incident management, your policy and strategies, and a list of any incidents. By the way, some incidents are quite simple. I can tell you, one client told me their security incident was this. They said they were having a closed door meeting, very confidential meeting. And 30 minutes into the meeting, they realized there was somebody in the meeting that was not supposed to be there. Well, they had discussed quite some critical issues. So this risk could come in very many ways. So have a good record of all these things that I'm talking about. So at the very least, if the data commissioner was to come and carry out an audit in your institution, you're able to show them that you've done some substantial work towards compliance. And lastly, and I think this was alluded to in the previous presentation by Mary, please prepare documentation for registration with the ODPC. One of the key things that the ODPC asks these digital lenders to prove is whether you've registered with the ODPC or you're in the process of registering, especially if you're on the list of institutions or sectors that must register as a matter, I mean that it's compulsory for them to register. Sorry for overshooting my 15 minutes, but I think if you have any question, let me know. Thank you.
Thank you so much, Lewuta. No worries at all. So I'd like to give the opportunity now to the participants. If you have any questions, you can be able to just shoot them on the chat. I believe perhaps if you're not able to unmute yourself, you can just mention on the chat. So just to perhaps get the ball rolling, I'd like to ask on the part of, I know there will be fines for SMEs. So are there any ranges on fines once it comes to data protection penalties or something of the sort that you can be able to get us on? I'll switch that to you, Labuta.
Okay, we've not seen any fines. We've only seen this one. There's been one administrative order by the commissioner, that is to the 40 digital lenders and to Aga Khan Hospital. But you see, when you look at the Data Protection Act, Section 63, it talks about 5 million shillings, either up to 5 million shillings, or in case of undertaking 1% of the annual turnover, whichever is lower. But Section 62 of the Section 62.2 of the Data Protection Act guides us to see what will the data commissioner be looking at. So Section 2 says the data commissioner will be looking at the nature, gravity, and duration of the failure. 2, was it intentional or negligent? What action did you take to mitigate damage or distress suffered by data subject? What was the degree of your responsibility? Did you put in place technical and organizational measures? Have you had previous failures? To what extent are you cooperating with the data commissioner? What are the categories of data involved? Mary talked about the normal data and sensitive data. If you're dealing with sensitive personal data, of course, there'll be greater scrutiny to you. Then, of course, the manner in which the infringement came to be known to the data commissioner. So if you suffered a breach and you did not inform the commissioner within 72 hours, then you see there's a problem there. Then the extent you've complied with any previous notices, if any, whether you adhere to codes of conduct or certification mechanisms. In Kenya, we don't have codes of conduct or certification mechanism yet, but I would believe, for example, if you have ISO 27700 or 27701, that the commissioner may look at that. And then any mitigating factors that you have applied and whether the penalty will be effective and proportionate. So if you look at the 12 steps that I've set out, if you're able to demonstrate to the commissioner that you've done a large part of those steps, then perhaps your fine will be smaller.
Okay, all right, thanks, Anthony. Brenda Babu is asking, could we go through the key ingredients of a data protection policy and whether the policy and data privacy statements differ? If yes, how? Maybe Mary or Anthony, you can be able to answer that.
Okay, so thank you, Anthony. Thank you, is it Kennedy, for that question. So the key elements could be, it depends with what your business does. So if, for example, you store your data on cloud services, as Mugambi mentioned, so some of the elements of your policy would be how do you manage your passwords? How is the internet usage, email usage? Are there different rights for are there different access rights depending on the categories of employees within your organizations? What information can your employees access? What are they not required to access? As Mugambi earlier mentioned, so it's sort of similar to your normal human resource policy. So it generally just breaks down the different access rights and the elements as to how your company is safeguarding data. So yeah, it depends with the operations your business is undertaking, but mainly those are some of the key elements.
All right, thank you, Mary. Kennedy Konya, thank you for the great knowledge sharing. You're welcome. Mugambi, this goes out to you. What are your thoughts on security risk on Google Workspace or Google Cloud as a cloud service provider?
Okay, I can't speak of a specific cloud service provider, but what you need to carry out, of course, is we're using a cloud service provider is to carry out a DPIA, analyze, like I said, look at the contracts, look at the terms and conditions, and see whether they are favorable and they comply with the Kenyan Data Protection Act. Then that way, you are able to identify whether it's an appropriate cloud service provider or not. You'll find that in some, I can't remember, but somewhere either in Scandinavia or Germany, where they've banned public institutions from using Google, the Google, is it called the Google Workstation, or I mean, basically that the workspace, the Google Workspace. So what does that mean? Is it appropriate? Is it not appropriate? I mean, but at the end of the day, it's for you as an organization to carry out the correct audits and ask the correct questions and then make a determination.
Thanks, Mugambi. Next, we have what are some of the guidelines that can be applied when responding to claims raised by a data subject to the ODPC?
All right, thank you so much. Thank you so much, Anthony, for that question. I think this has also been mentioned, but at a high level during the presentation. So some of the key considerations would be: one, are you registered if you're a data processor or data controller? Two, did you get consent from the data subject when processing this data? Those are some of the key things that the Office of the Data Protection Commissioner would be looking at. Others would be, was it intentional? Was it, is it that you don't have mechanisms within your organizations to protect this data? So mainly those are the things that the office is looking at, and as mentioned earlier. Thank you.
Thank you, Mary. Jane Mushiri is asking what sort of enforcements are likely to be applied to ensure that data protection is taken seriously in Kenya. Mugambi, I'll throw this to you.
So when you look at the regulations, there are certain things the data commissioner might do. One, of course, is I mean, when you look at section 63, it's a fine, the 5 million or 1%, whichever is lower. But then there's also section 65 that talks about damage compensation to a data subject, and it talks about damages. And some of the damages, it includes what it calls distress. How do you quantify distress? You never know. The commissioner or the courts may say distress is, so you may be fined maybe 5 million shillings, and then as an institution, you see that's pocket change for you. But then they say the damages to maybe 1,000 data subject will be at 10,000 shillings per data subject. So you see the loss is larger. But the commissioner may also give you a period of time for you to comply. Say, we've come and carried out an audit. We give you 6 months or 3 months or 90 days to do ABCD. If you don't, we will take out some action against you. So there are different kinds of enforcements that are available to the regulator and to the courts under the Data Protection Act.
All right, thank you, Mugambi. To answer your question, Wendy, yes, we will be sharing the slides and the recording for you to be able to go through at your own convenience. Gilbert Morris asks, how can we measure compliance in terms of data protection in an institution? And he says, thank you for the enlightenment, Mugambi.
Measuring compliance, we have different, I mean, here you require an expert who is able to do it, because we have what we call ad hoc mechanism and up to mature. So it depends on your level of maturity. And your level of maturity depends on like the 12 steps. Which ones are you compliant with? Which ones are not? So the highest level of compliance will be like you'll have put in place all those mechanisms, you've carried out audits, and you've acted on those audits. But if, for example, you just have a policy that shows that you have a very weak, your maturity is quite low. You have ad hoc maturity level. So it just depends. But here you need somebody just to audit your systems and see what you've done. But I said the highest level is that you have all these processes, you've carried out audits, and you've acted on the recommendations of the audits.
Thank you.
Sorry,
Mary, go ahead.
So just to add to what Laibuta is mentioning, other things that would help you maybe conduct that is to check how your data is stored. How do you process this data? Are you abiding to the principle of purpose limitation, minimization, accuracy, storage limitation? So these are some of the other key considerations to check even as you're conducting the data protection impact assessment. Thank you, Anthony.
All right, thank you, Mary. I'll also throw this question to you from Opara. In regards to complaints made to the ODPC, what if one lodges a complaint and the office finds no basis on the same? Can they seek any other legal redress other than going through the Office of the Data Protection Commission?
Is that for me, Anthony?
Yes, that's for you, Mary.
Yes, so thank you very much for that question. The complaint handling procedures are that if in case you lodge your complaint with the office and after the assessment, they don't find any legal basis for this complaint, you can actually appeal your decision within the same office. And I know there's also an option of seeking legal redress in the courts. So yes, there are remedies and there are avenues to seek redress.
Thank you for that, Mary. We'll take the last question from Mary Njoroge. What are the prerequisites of implementing the Data Protection Act? I'll throw this to Mugambi at this.
Simply, you need resources. You need financial resources. You need human resources. One thing that I always tell anyone that I'm working with, it will require money. For example, if you have to work with Adept to help you comply, if you have to work with myself, we'll demand some form of compensation. And of course, secondly, you require people who do understand what data protection compliance is all about. Not just somebody that has read the Data Protection Act, but also understands what are the programmatic, what are the project aspects of complying with the Data Protection Act. Also, she's saying in terms of other information and data. Okay. You will find that, and I find myself, you'll find that data protection aspects, as I said, there's an intersection with, for example, cybersecurity issues with information, but mostly with information systems management or with information management. So you find as an organization, if you have very good cybersecurity protocols or you have very good information systems management, then compliance with the Data Protection Act will be quite easier for you.
Okay, all right. Thank you so much, Mugambi. On the chat, I've seen that Mugambi has shared his contacts. So has Mary. So in case you have any other questions or need to consult further, you can be able to reach them through the contacts that they've shared on the chat. For everyone that's been able to join, there are others who registered but weren't able to join as well. We will send them a copy of the presentations done by Mugambi and Mary, and also the recording for them to be able to reference back to. So thank you so much, Mugambi. I'd like to take this opportunity to really thank our two speakers, Mugambi and Mary, for being able to join us this morning and being able to give us an intro and take us through the data protection laws in Kenya. It's been very, very insightful knowledge sharing types. So just to also mention that next week we'll have a following webinar This time we'll be discussing security, both for technical and organizational measures to ensure security of personal data. October being Cyber Awareness Month, which wouldn't be right for us to end the month without having a session on security. So next week we'll have a webinar, again being hosted by, being taken to by Speaker Mary, and we'll have a speaker who will be on that day be able to take us through security. So thank you so much to all of you for joining us, and we'll keep an eye out on our social media pages where we'll be sharing the link to register and sending out more information on that. So thank you so much, and everyone have a good day. So thanks. Bye bye.
Thank you so much, Anthony. A very good day to everyone. Bye.
Good day,
Bye
Kwaheri.
bye.